Hello, everyone. Good evening. Hope you're all doing well tonight as we get towards the end of the week. Thank you again for joining us for tonight's very special webinar. I'm Dr. Zarmi Shanawaz, the medical director here at Face to Face Health. It's nice to have you all join us. Unfortunately, we do normally have Dr. Ami Shah, who's our founder, who also joins us on these webinars every Thursday evening. Unfortunately, she wasn't able to make it, so she does send her apologies. I just want to let you know a little bit about Face-to-Face Health for those of you who are not familiar. We are the first children's integrated holistic healthcare platform for children and their families. On our platform or using our platform, you can access providers from all different specialties. We have dozens of specialties ranging from general health, such as pediatricians and physicians, to mind-body experts, all the way through to financial and legal experts. And of course, we'll be highlighting one of those providers for you tonight. So Katya, are you able to switch your video on? There she is. Hello.
Hello.
Nice to see you.
Nice to see you.
Great. So let's go ahead into introductions. This is Katya Sveldov, who is an estate and special needs planning attorney, and she's the principal of Sveldov Law PLLC based in New York. Her practice focuses on estate planning, special needs planning, Medicaid planning, guardianships, and probate. She is a graduate of Cornell University and received her law degree from Brooklyn Law School. Prior to law school, she worked in investment banking and risk management. That must have been fun, Katya. But now her passion really lies with helping families navigate the dynamics of legal implications of planning for special needs groups. So welcome once again, Katya.
Thank you.
Certainly, you know, when children receive a diagnosis or families receive a diagnosis of special needs, ADHD, developmental disabilities, you know, I think we all tend to focus on medical and educational and developmental requirements. And I think a lot of us tend to forget the sort of the legal and financial ramifications and implications of those sorts of diagnoses as well. So, you know, we're very thankful for your expertise tonight. So before we actually move on, can we actually define, or, you know, how would you define special needs when you're talking about this group of children?
So it's quite a varied definition, and every child is unique, of course, with its own special story. It may be somebody who was diagnosed with a disability at birth, such as Down syndrome. It may be a child who received a diagnosis a few years later, such as autism. It may be a child who was growing up healthy, but then unfortunately was in a car accident and became disabled as a result. It may also be a child who was growing up healthy and then developed a mental illness in their teenage years, such as bipolar disorder. What all of these have in common is a potential lifelong inability to make financial and healthcare decisions for themselves. And it, of course, leaves the parents not only with the lifelong care for the child, but it also forces the parent to do lifelong planning.
Right. So I actually have a little off the cuff question for you. So where do most of your referrals actually come from? Is it generally the families, or have they generally been recommended that they should seek help? Where do you find that the funnel actually lies?
Other attorneys,
Mm-hmm.
psychologists, and psychiatrists who work with these children and their families, financial planners and accountants, and generally other parents and other past clients who have worked with me and have listened to me speak and read my blogs about the issues. As they hear and see, they learn to recognize that certain things must be addressed and thought of.
Right. Okay. So, Katya, can you actually tell us what are the goals of special needs planning? You know, when we sort of first get into this,
So
what are we really looking at doing?
So the main goal is to balance the parents' present and future needs, and the present and future needs of the child. And the process may seem somewhat overwhelming, but it does not have to be that difficult. You do need to take the time to understand the basics. You need to get the professional help, and you need to proceed step by step in an organized manner. Again, the goal is to plan for the future care of the child. The goal is to communicate that plan, because if you do a great plan but nobody is aware of it, then it's almost useless. And lastly, and just as importantly, it must be revised as needed. As the child grows, as the family changes, the plan must be re-evaluated every few years to see if it's still appropriate.
Right. And is that something that you leave up to the families, or is there kind of a regular protocol perhaps that you
I
might?
usually follow up with families once every 3-4 years to
Right.
see where they are and what is going on. And sometimes we check in and nothing needs to be done, but sometimes things do change. The child's health condition changed, the family composition may change, they had a new child, or the family composition may change. There was a divorce, or the family composition may change in that the family got much richer than before, and there's now better ways of planning that are available.
Yeah. Well, that would be a nice problem to have, wouldn't it?
Yes.
Okay. So what actually happens, what are the risks really of, actually, I think I've skipped a slide. What are the risks of not planning, I guess?
So before we get to not planning, I would like to talk about bad planning. Can you go back to the
Yes.
previous slide? You're right, this one. So the biggest, most common bad planning that I see is when parents or other family members leave money to the special needs children outright. They do it either directly through a will, or they list the child as a beneficiary on accounts. Some grandparents are not even aware of the extent of the child's disability, and some parents may simply not be aware of the implication of this gift. The result of this is absolutely disastrous. First, if the child does not have the mental capacity to manage the money, then it will either be wasted or a third-party guardian gets appointed. Second, if the child is receiving means-tested government benefits, such as Medicaid, he will be disqualified if he receives an outright inheritance. So please do not leave the child money outright ever. Now, other people go to the opposite extreme and they decide to completely disinherit the child. They understand that the child cannot handle the money. They understand that they don't want to lose the government benefits, and so they leave the child with nothing. This is also quite a big mistake, because what if the child wants to live in an apartment of his own later? What if the child needs medication that is not paid for by Medicaid? What if the child has capacity and wants to go to a trade school and needs tuition money? If the parents left nothing, then none of these things that can enhance the child's life will be available. So, yet other parents, but number two, leaving inheritance through a non-specialized trust is just as bad as the first one. So I don't even want to talk about it. So another big mistake that I also see frequently is parents think that they found a solution to these two problems. And they say, instead of leaving money outright, or instead of completely disinheriting the child, we will leave the money to a child's sibling. And then the siblings of the special needs child will take care of their brother. That's another big mistake. First, if the sibling himself later goes through divorce, then all that the money that was in the sibling's name will be subject to the claim of the divorcing spouse. It will simply be lost. And second, if the healthy sibling gambles the money away, or has creditors, or dies and leaves money to his child, again, the money will be lost to the special needs child. So they will be left with nothing. And of course, the other big mistake is doing no planning at all, because people just say this is so overwhelming and I have so many other pressing needs right now, such as the daily taking care of the child. I will just leave it alone. that's even worse. Can we go to the next slide?
Yeah, absolutely. Before we actually move on, I know you and I had a discussion prior to the talk, and one of the common myths that we discussed was that a lot of people think that you must completely disinherit a special needs child as soon as they turn 18, right? So that this is something that you commonly see
This
occur.
is absolutely right. That was number 3, and this is not a good way of doing the planning. There are much better ways, and we'll talk about
Yeah.
them in a little bit.
Yeah.
So the mistake of not doing any type of planning is the worst of them all. Because if you do not plan yourself, then the government plans for you. We do have laws that say what will happen to the money, and then you're subject to intestacy laws. The judge will determine a guardian for the child who may be a stranger to your family. I've seen it multiple times when the judge appoints a friend of his or hers, and even though there may be family members, but if there are no documents in place, why not, especially if there's money? Or if there is, again, no planning done whatsoever, no special needs trust, no thought put in the plan ahead, the money is likely simply to run out because it's going to be mismanaged or spent on unnecessary things. Most importantly, the child will not be taken care of properly. After we spoke today, I received a call 3 hours ago from another colleague who was calling me asking for suggestions. A woman's parents both died, and they left a 50-year-old daughter with mental health issues. The parents had done no planning. Woman has been now held by a hospital for 2 years
Oh my gosh.
because the hospital has applied for a guardianship over this woman, and they want to put her in a nursing home. And she's 50 years old, and she's crying, and she's trying to fight it, saying no, she's too young, she wants to live in an apartment with an aide. But there are no intermediate options for her. There is now a 10-year waiting list in New York for group homes, assisted living facilities that are paid for by Medicaid. And she doesn't have money or anyone who cares about her to help her live in an apartment outside. So my colleague has spent over 100 hours recently researching and trying to find a solution for this woman, and there's nothing available. She will spend the rest of her life in a nursing home, not being allowed to go outside, which could have been avoided had her parents actually done some planning ahead of time.
Yeah. So sad. So
So,
talking about, I guess, what parents then should be doing, clearly there's a integral need.
so the very first things that the parents should do, and I'm sorry if I'm depressing everybody, but this is what I do. I talk about incapacity and death, and it's actually optimistic because you can think it through and you can plan ahead. So
Absolutely. We're not helpless.
you're not helpless. There are things that you can do. So the very first thing that all parents should be doing is planning for themselves and for their own incapacity. Just like on an airplane, before you put on a mask on a child, you have to put on the oxygen on yourself. So power of attorney protects an adult in case he's incapacitated, uh, and makes a determination who will make financial decisions for you. Healthcare proxy determines who will make healthcare decisions for you and speak to doctors. Parent disposition of remain plans the funeral. The will, if your child is a minor, will appoint a permanent guardian for the child. And the trust is the most versatile document of them all. It avoids court probate, it may help with taxes, and it may help with the parent's own long-term care planning. But the parent must think it through. Who will pay the rent if they are in a hospital and the child is still home? How will the parent pay for his own long-term care if he's disabled? And how to avoid probate with court, which now takes approximately 1 to 2 years because our courts are so backed up. How to avoid it so that the money is actually available after death for the family.
Katya, I have a question, I guess, for you. The person that you give the power of attorney to, can and often is different to your healthcare proxy, right? They don't have to be the same person.
They do not have to be the same, absolutely not. They frequently are the same. Most people do not have that many people that they actually trust and want to give the power over their life to, but it does not have to be the same. It's just that the two take care of very different things. Power of attorney takes care of all things financial, bank accounts, real estate, brokerage account, retirement accounts, everything that has to do with money. And the healthcare proxy takes care of everything that has to do with health.
Got it. Okay. Shall we move?
These are the documents that I talk about with every single parent, regardless of whether or not they have a special needs child. Now we're getting to actually the special needs planning.
Right. So this is kind of level A, and then we're moving into.
Right. Yeah. So now, in addition to what I just said above, which every parent must have, now you must think through the unique issues of planning for special needs children. You must think of what kind of care will the child need? How old is the child now, and what are his disabilities? You must also think, what are his capabilities? What does the child want? If your child is 5 right now, the child's wishes may not be so important, and you definitely know what is best for the child. But if your child is 20 and has high functioning autism and may be able to live independently, his wishes must be taken into account. Now, I also mentioned this will change as the child ages. There may be new underlying health conditions. There may be new cures that are available. Again, and it's completely unique to every family. Maybe the child is physically disabled, but is perfectly fine mentally. And then she herself will decide all of these issues as she becomes an adult. And maybe there is a scientific breakthrough that will happen and the special needs part of the planning will no longer be necessary. That's why you plan for the situation as it is right now. You think of the future, but you have to revise it as time progresses. Next slide. So there are 5 things that you must do and think through if you have a special needs child, and we will go through each one of these individually. And just remember, as the child ages, he will have his own emotions and the need to participate and to be accepted. Again, it's fine to make all of these decisions now if the child is young, but if as he gets older, he should be participating in this.
So you're encouraging kind of open communication.
Absolutely. As much as possible, you have to talk to the child and see what he likes and see what he wants. Again, you're the parent, but, and we'll talk about it a little bit further, what happens at the age of 18 or a little bit before 18. But to the extent possible, you want your child to cooperate with his own planning. Okay, next slide, please. So the Memorandum of Intent is not legally binding. However, it is incredibly important. If you suddenly pass away, you as the parent, who will know what to do with your child? What kind of doctors does your child go to right now? What kind of medications is he taking? What therapists? I saw a child today who's 2 years old and has severe form of autism. There's a huge team involved in his care, and the mom is on top of everything. But what happens if something happens to the mom? So again, for some people, this may not be that relevant because the child may be verbal and communicative and is able to tell everyone. But for others whose children are nonverbal or young and have a whole team taking care of them, it is crucial that you write it down. It is a personal letter from you to the people who will care for your child when you no longer can. And then you write down what you want. Who should the child live with? If there is a choice. Again, some people do not have that much of a choice. They may have one brother or one sister, but you should write it down. Should the child live in an institution or in a private home? And don't think that institutions are necessarily bad. For some, this may be the best choice, and institutionalized actually may have activities and socializations And when there's limited money and the child has lots of medical needs, this may be the best solution. Again, this memorandum will absolutely change as life progresses, which is why I say every few years, at least look at it. At least look at it and see what has changed. Again, I've seen different situations. I've seen one boy with autism graduate from MIT. And yeah, I know another girl with autism who will remain nonverbal for the rest of her life, and she will need 24-hour care. You will know where your child is much better than me or anyone else as life progresses.
Yeah, and before we actually move on, I just want to highlight, please, if you have any questions, feel free to send them through in the Q&A, or you can chat them as well. And we will do our best to address those questions towards the end of the evening. Next slide, Katya.
Yes, please. So as you're writing the memorandum of intent, you must be simultaneously thinking about the child's future income and expenses. Again, for some, this may not be relevant. If the child is able to work, then this question is moot. But for others, if the child cannot work, then you must understand the eligibility qualifications for SSI and Medicaid and food stamps. SSI provides a monthly stipend to pay for living expenses. Medicaid takes care of medical services, including therapies, as well as care at home. And food stamps provide food purchasing assistance. All of these are means tested, meaning that the child's assets will be looked at. You must understand what it does. You must also think of the child's needs, of course. Will she require 24-hour care? Or maybe not. Maybe she will require only money management by somebody else, but she may be able to live independently. I've seen a lot of this where people are able to function and eat and shop and do the basic cleaning, but they do need somebody else managing their finances.
Yes, the higher functioning, that's the issue.
Absolutely. This also actually applies to people with individuals with mental illnesses.
Yeah.
I have a friend who has a bipolar son. She had to buy an apartment for him because he was going in and out of hospitals and mental institutions. When they would release him literally out on the street. She could not take him home back with her because he was physically dangerous. She could not rent an apartment for him because the landlords would kick him out when he would go into a manic episode. So what she ended up doing was purchasing an apartment for him. Of course, it was not in his own name. It was done through a trust. But this way she was assured that when he leaves the hospital, he's not going to be homeless. He's going into an apartment from which no one is going to evict him. So this is something that must be looked at. And again, it really depends on the child's needs and the family circumstances. One thing that I wanted to say I am not discussing here is special education, right? Of course, on top of all of that, one of the benefits that people are entitled to is to the child to have to be educated, and there are lots of programs in New York. And if the public school cannot accommodate, then the state will have to pay for it. I'm not an expert at special needs education at all. There are other experts, but I just wanted to bring it up that as the child is growing up, this is something to definitely consider as well.
The final point here, project the cost over child's lifespan. Who is our resource for doing that generally?
It's a team. All of this is done really through team planning. There are financial advisors who can calculate the costs of certain things. There are lawyers who can advise on eligibility of various government benefits and how the child will qualify for them. So projected. And of course, there are doctors and therapists who work with the child who will give you the most realistic projection because they see your child on a regular basis. And if they are honest, again, I work with a psychologist who she sees a child at 5, she can basically project whether or not the child will ever be able to work or not. As you're working with the therapist, they will be able to give you the most accurate assessment of your child's needs, and then to calculate what that actually means, you should be working with a lawyer and a financial advisor.
Got it. Thank you.
So the centerpiece of planning for a special needs child is a supplemental needs trust. The purpose of it is to place money in the trust for the benefit of the child. The money in the trust can be used for almost all types of activities. There are some limitations, and we're not going to go into the nitpicky now, but assets in a properly drafted and properly administered S&T will not be counted as available assets when the child is applying for government benefits such as SSI and Medicaid. The trust disbursements, the trust income, will also not be counted as income. I emphasize that the trust really must be properly drafted. There was a fairly famous case a couple of years ago when there was one word missing from the document. I mean, these trusts are 40 pages long, and there was one word missing from a particular paragraph, and Medicaid appealed, and the judge ruled in favor of Medicaid, saying, yep, you're right, it's not properly drafted, and all the assets in the trust are now available, and the child is not eligible for Medicaid. So obviously that was a failed planning. The trust must be drafted properly. The purpose of this is to ensure that the child has the best quality of life, because everything in it can be used to pay for medication that Medicaid does not pay for, child's vacation, an additional home care aid, education, vocational training, really any, housing, where the child, if the child wants to live in an apartment, anything and everything. And if we have time, I'll go into a little bit of a difference between third-party supplemental needs trust versus first-party. But this third-party means that the trust is funded with the assets of a third party, meaning not the disabled individual himself. So it can be done with the assets of a parent, it can be done with the assets of a grandparent, of a sister, of anybody else. It's third party, not the child himself. And then the assets are there. If there's any money remaining in this trust upon the child's death, then the money gets distributed based on how the grantor, the person who created this trust, wanted it to be distributed.
Right. And then obviously this can be added to over the years.
Absolutely. Yes. People add to these trusts over the years, again, as life progresses. Absolutely. And we'll talk about funding on the next slide, actually, about what to do. So I cannot emphasize this enough. Again, another big mistake that I see. I can draft the most beautiful, most perfectly drafted trust possible. However, the next step is always on the parent, on the grantor. The trust must be funded. You must actually put something in there. Otherwise, it's a useless piece of paper. And you wasted money on a lawyer. And most importantly, you left the child exposed with no money. So how do you fund the trusts? And what can you put in the trust? You can put anything you want. You can put the house or an apartment or a brokerage account or a bank account. You can name it as a beneficiary of your retirement accounts. You can put life insurance policies in there. If you want to leave assets to your child, put it in the trust or name the trust as a beneficiary. And a lot of people say, but we are poor and we don't have the money to put anything in the trust. So the answer to that is, and really there's, aside from making more money, but again, it's not very realistic, especially if you have a special need child and usually one of the parents really has to stay home more. The answer is buy a life insurance policy. Especially if you're young, it's not that expensive. And you name the trust as a beneficiary of that life insurance policy. If you are alive, while you're alive, you will keep working and supporting your child. So that's not a problem. But if you die, the child will have money available to take care of his most pressing needs. So it's really worth it. And it will, even if it's $100,000, so $200,000 policy, it will pay for the child supplemental need aid, an aide who will actually care for him. So incredibly important, and I put that on a separate slide in big letters. You must take that next step and actually put something in the trust.
And again, just to acknowledge, the revenue for the trust can come from multiple sources. It doesn't have to be one grantor, right? It can
be, yes, there are some tax implications to that. And so people have different questions and issues about why they are creating it. So, but yes, there can be multiple grantors for a supplemental needs trust for one particular child.
one child.
And yes, people definitely add to it over life.
Got it. Okay, let's move on to guardianship because we have had some questions about that.
So once the child is older, it may come as a complete surprise to people that even though the child does not have capacity or willingness to make decisions, once the child turns 18, parents lose all ability to make any types of decisions for their child, regardless of his level of capacity, even though you've always cared for your child. So how do you address it? If the child has capacity, and lots of them do, right? High functioning autism, some developmental disabilities, other things. If the child does have capacity and understand things, at the age of 18, you can ask the child to sign a power of attorney and a healthcare proxy, naming you as the primary and naming someone else as the successor. In that case, you will be able to continue to speak to the child's doctors as well as speak to Medicaid and all other providers on his behalf. This option is absolutely the best because it's easy, it's fast, but of course it also has downsides. The biggest downside is that the power of attorney and the healthcare proxy can be revoked. If the child has capacity to give it, he also has capacity to take it back. So, and it frequently applies to children with mental health issues, schizophrenia, bipolar. If they're contentious and they don't think that parents have their best interest at heart, they will just revoke these documents. But in other cases, the child does not have the capacity to sign these documents. And in that case, you must start a guardianship proceeding in surrogate's court around the age of approximately 17 and a half. Parents should be designated as the primary guardian. Someone else should be designated as a successor guardian. I cannot tell you how many cases that I've seen where that did not happen, where the parent was designated as a guardian and was making decisions for the child, and then the parent is gone. And then the child is left with nobody to help him to make decisions. So always I ask primary and then a successor. The other,
sorry. No, I just had a question. You'd mentioned to start that process when the child is about 17 and a half. I know earlier on you had mentioned that the courts were pretty backed up. So this particular process is about a 6-month process, and it's not a years-long thing.
It's about a 6-month process. So normally it should start about 17 and a half at this point in time, simply because last year courts were closed for 2 months and then they started functioning again. And, they're actually getting better now and trying to catch up on things, but not on everything. So I would give it, at this point, I would give it a year.
Right.
because right now I'm still filing things, and they acknowledge that they have received paper from me, so it's not going into complete void, but yet nothing is processed. In fact, I just got today something back that I filed in the summer, in
Wow.
July. So it's moving, but slowly. But this is a decision that must be made, and it's quite serious because um, it's lifetime. The guardianship, once you get the guardianship appointment, it's a lifetime appointment, and the child loses his legal rights, right? You will always be there making decisions for him. On the other hand, again, I cannot tell you, because especially in the past when government agencies were not so strict and were not paying attention, some people just failed to file for guardianship, and they would always be taking care of the child's needs. And then again, something happens to the parent, and then there's nobody with authority to make decisions for this child or even know what is happening. So if you think your child does not have the capacity to take care of financial things or healthcare decisions on his own, you must file. It's called a 17A guardianship, and you must file it. Just one other thing that I want to point out is another thing to do before the child turns 18 is you have to look at the government benefits, and you actually have to start looking at them a bit before the child turns 18. SSI, as I mentioned, provides a monthly stipend, but SSI also has a 3-year look back. So if the child has any money in her name, it must be transferred out at least 3 years before you actually apply on behalf of that child for SSI. Medicaid is a bit different. They look at both parents' assets and the child's asset until the child is 21. And then after 21, the child is considered to be independent. And you must also look at housing options. And we're in New York. Housing is the worst. I mean, again, I'm crying every time somebody asks me that question, because the answer is there's nothing. There are huge waiting lists for group homes, and they're based on need, somebody who has absolutely no other place to go, or moderate need, or medium need, and it takes years. So you must start looking at these options as early as possible and figure out, where will the child live? Will he continue living with you? Will he be able to live independently? And if not, and he has to go to an institution or a group home, then it must be planned for properly.
Yeah, and again, just going back to something that you mentioned at the beginning, a lot of this may seem overwhelming and a little bit gloomy, with the courts backed up and not a lot of options for housing. But, I think the purpose of these sorts of talks is to kind of acknowledge that there are these issues, there are these barriers, and if we start early enough, that we can take, proper steps to ensure that we're all in a good place.
Absolutely, because, and not doing things only makes it worse.
Yeah.
So it must be done while thinking it through. It can be done step by step. You don't have to do it all at once, but this is something that must be done, because otherwise the government will decide for you.
Yeah, we don't want that. Okay, we did discuss SNTs. You had briefly mentioned that there were other types of trusts, I think.
So first party is SNT is if the child has money on his own. And this may happen for two reasons. One is the child received an inheritance, which is one of the big mistakes that I mentioned.
Yeah.
And of course cannot handle money, and so there must be first party SNT then set up. It requires government payback, which means that if there's any money left over after the beneficiary's life, after the beneficiary's death, everything that remaining is going to the government. Another scenario when this happens is when the child was in an accident and there is either a medical malpractice award or personal injury award, and again it's awarded to the child directly. In that case, it's being done taken care of with first party SNT. A trust is a must. one or the other trust is an absolute must, because again, Medicaid, and I keep going back to Medicaid, is because Medicaid pays for all the healthcare. And most no other insurance will. And Medicaid pays for long-term housing, and Medicaid pays for long-term care. And that is a means tested benefit, meaning if the child has more than a certain amount of money, they're not eligible. That is why people set up either third-party S&Ts or first-party S&Ts, because they need to keep the child eligible for Medicaid.
Right. Okay. We do have a couple of client cases because I wanted to sort of understand what this may look like in real life. So perhaps we can go through the first client case, and then we do have a few questions as well. Perhaps if we can go through those, and then we have time to come back to the second client case, we will. But
Sure.
let's
So
discuss this case of
this
autism.
is a family that I helped with. It is a lovely family with 7 children, and their youngest one will need care for the rest of her life. So the parents wanted to make sure of actually 2 things. They wanted to make sure that she continues to have government benefits. They also wanted to make sure that they leave money for their other 6 children, who will not be burdened. So how did and they also wanted to take care of themselves in case one of them became incapacitated. So it's a very step-by-step process. We created power of attorneys and healthcare proxies for the parents, right? And they were in their late 50s at that point. As you know, things may happen. It protected them from their incapacity in case one of them got sick. The other one would be able to make decisions for them in case there was no surviving spouse. One of the 6 other children was named as the successor. They left, they created wills. They left things to each other because all of their children were common, and they were fairly confident in each other that the other spouse was not going to waste the money. They created simultaneously a special needs trust, supplemental needs trust for their youngest daughter. They named that trust as a beneficiary of their life insurance policy. They also transferred one of their 2 properties to that trust to be used for her benefit, and they told grandparents about the supplemental needs trust, and grandparents transferred some money into the trust. They were themselves trustees, the managers for now, but the trust was set up such that if the parents passed away or became incapacitated, one of the other 6 children was becoming the trustee, the manager. And then the daughter was 17, and we applied for guardianship for her because she was nonverbal. And we got guardianship for her. So the parents, again, would continue making healthcare decisions, take care of her, but we made sure. So the parents were the primary guardians, and we named 2 other siblings actually as successor guardians, so we took care of everything. We took care of the financial needs. That child will be taken care of, and her siblings are not financially burdened with her care. And simultaneously, the 2 of the siblings who agreed will be making healthcare and financial decisions for her as well, dealing with Medicaid, dealing with housing issues. She will not be left untaken care of.
Yeah.
So this was an example of very proactive planning. They knew because in the community there were other people that they know with these issues, so they knew they had to take care of things.
Yeah, and certainly, and the reason that I really like these client cases is that when it's laid out in this kind of logical stepwise fashion, it really shows that, this can be done if planned for properly. So Katya, let's break there. We do have a few questions which I'd like to get to. And as I mentioned, if we do have time, we can come back to, that second client case. So first up, I have a question from Mitra. From which age of the child do you suggest we start to do the planning? And And second to that, Mitra's asked, who will prepare this memorandum? I'm presuming the memorandum of intent.
Mm-hmm. So the first question is, at what age to do the planning?
Correct.
So it's a two-step answer. The first is you must plan for yourself as the parent. And the answer is now. The answer is if you are over 18 years of age, and I assume you are since you are on this call, you must do the planning for yourself now because we don't know what will happen. I've had clients who were, the youngest client that I had was 36, who was standing on a sidewalk, hit by a car and became a vegetable. Not even driving, not even engaged in any, and there was nothing. There were no documents in place. It was a huge, horrible guardianship mess.
Yeah.
So for yourself, you must plan now. For the child, you must plan as things progress. So as you're planning for yourself, you're thinking for yourself, power of attorney, healthcare proxy, will, to name a guardianship for the child, and a trust to make sure that the money does not go through probate, to make sure that the non-special needs children do not get the money too early outright, to make sure you name a trustee who will be managing the money, and to create that supplemental needs trust to make sure that government benefits are not jeopardized. You can do that now. As the child ages, there will be additional type of planning, such as when the child is closer to 14, 15, you will see what is the child's capability and you may plan for SSI. As the child is turning 17, you will plan for guardianship or not. Maybe the child is not needed and is perfectly capable of signing power of attorney healthcare proxy.
Yeah.
And as the child ages and the need, again, I've had clients, who came in, the child was completely fine and normal, and at 17 developed schizophrenia. At 19 developed bipolar. I've had clients where the daughter developed bipolar at 15, she was diagnosed already at 15. Yeah. She developed it earlier. It really depends on your family. And the second question from Mitra is, who will prepare this memorandum? Yeah. You will, in consultation with the attorney, but also really in consultation with, all I can provide is guidance. Please try to answer these questions. And then some people write 3 pages and some people write a page. And it really, again, it depends on what you want and what information you have and who you have in the family and what kind of needs the child has. So it's really again, we can provide guidance and we can provide help and we can provide examples, and we empower you to do it. And don't just throw it out, but the onus is on you as a parent to do this properly.
Yeah, and as you mentioned, it's an ongoing conversation. The memorandum of intent can always be changed and adjusted through the years as well, right? As you mentioned,
absolutely.
Documents, you can go back to it. Great, thank you. Yes, in terms of access to handouts, we will be sending a recording of this webinar to all the attendees. So you will have access to all the slides there. Iona, I hope I've pronounced that correctly. Okay, we have a question from Tamara. What is the cost of setting up a trust?
So I can talk about myself. I cannot talk, of course, about other attorneys. And I can tell you that my planning costs vary from approximately $2,500 per family to approximately $10,000 per family. And I hate to say this and I hate to sound like a lawyer, but it depends. It depends on what you need and what your family is. Some need 1 trust. Some need 2 trusts. I had a client yesterday actually who came in all humble, and then it turns out that she has an estate tax issue, meaning that her total assets are over $11 million. So in addition for her of setting up a supplemental needs trust for one of her children, we are also doing tax planning. and making sure that upon her death, one, there's liquidity to pay these taxes, but also that these taxes are actually minimized. Some people have businesses, so different. Some people have just a couple of bank accounts. It really, some people have problems with their family that are not special needs, such as stupidity issues or issues that are
Ignorance,
but also strife within the family. I've had people coming to me and saying, actually last week I had a client who said, the only family that I have is my brother, and I haven't spoken to him in 10 years, and I never want to speak to him, and I want to make sure he has no control whatsoever over anything.
Yeah.
It involves somewhat different type of planning. So all I can give you is a range, and then work with each individual family, and it depends.
Yeah, on the complexity.
Mm-hmm.
I'm not entirely sure that you would be able to answer this question. I suspect this may be more of a medical question. What criterion is used to be permanently hospitalized? I don't know.
So I can say, I cannot answer about hospitalized because I'm not a doctor. I can tell you about permanently institutionalized, which is a somewhat different story. And I think it relates to the example that I gave earlier in the presentation about the 50-year-old woman, which the hospital wants to make sure to put in a nursing home. They believe she cannot go safely outside. So normally, hospitals cannot actually release a person out on the street if they believe the person will become homeless or a danger to himself or a danger to others. And if there is no safe discharge plan, if there is no family member who is able and willing to take care of that child, and there's no money to hire somebody to do that, and the person cannot take care of themselves, then it's permanent
institutionalized. Yeah, and I suspect that is where the question was focused. I think it was probably permanent institutionalization instead of hospital, because of course that is something that psychologists, psychiatrists, etc., use certain criteria to pop people into hospital or schedule, I should say, against their will.
Right.
Katya, we had a couple of questions that came in even before the webinar. We have answered all of the live questions for now. If anyone else has any questions, feel free. But one is from a provider perspective. As you know, we have so many different types of providers on our platform. How can a health professional, such as an OT, PT, or speech language pathologist, assist parents when going about the legal process? I get a lot of questions about how to navigate the process, especially when it comes to wanting their child to receive services outside of the Department of Education and in a private clinic setting.
So I can answer part of it, but not all of it. How can the service provider help with the legal process is twofold. One is during the guardianship hearing. In order to receive a guardianship appointment, the parent must prove to the judge that the child is incapacitated. And how do they actually prove it? They must bring 2 or 3 letters from service providers, such as doctors or therapists that have known the child for several years, seen it, and can testify to the effect that the child does not have legal capacity. So that is one. Another way that the providers can actually help is when we're talking about planning and estimating the child's needs, the therapist may be able to give an honest answer. Parents are so hopeful. Parents are really hoping for a miracle, that something will come up and autism will be cured and cerebral palsy will be cured and the child will leave the bed and become normal. And I hope so as well. That being said, given today's current science, the therapist may be the best person to give you an honest answer about what you should be planning for. This is what the child's life is likely to be given the state of the current science. You must face the reality and plan appropriately.
Yeah, and we had a second question, which I think probably segues from the second part of the last question, which is how can I help parents get reimbursement for assistive devices, which I don't think is in your kind of scope of
I
practice.
No, I'm sorry. I do know people who deal with this, but it's absolutely beyond my area of expertise.
Yeah, and just to from our perspective to answer that question again, that is something that an OT, a PT would be able to help with. So other kind of healthcare professionals, and of course the other big resource that we also have on face-to-face health are our parent coaches and our parent advocates. And I don't know if any of you were attending our webinar from a few months ago, where we had our parent coach Karen Spector, who knows everything there is to know about how to kind of, work within the system and get as many benefits for your child as possible. So a parent coach or a parent advocate would also be an excellent resource for that kind of question. Okay, I have another kind of client-focused question. What can I put in place for a high-functioning autistic child who is under 18 years old? Can I appoint a cousin who turns 18 2 months prior to my child? I know we touched on this during the slides, but anything you'd like to add to that scenario?
So I would not appoint. So one, there are two questions actually within it. First, you cannot appoint as a fiduciary anybody who's below 18 years of age.
Okay.
You just can't. Because if something does happen and they need to act, they will not be able to. Nobody will accept their signature. Nobody will accept their authority. A person below 18 years of age cannot act contractually, period. For high functioning, that being said, for a child with high functioning autism, I would ask that child that she turns 18 years of age to sign a power of attorney and a healthcare proxy. You can explain to them that, mommy, daddy will continue paying the rent, will continue speaking to the doctors. We need to have it done. Again, it has to be a properly drafted power of attorney, but high functioning children with autism usually, that's why they're high functioning, have the capacity to sign these documents. So those are the two immediate things to do upon the child turning 18. But you must also consider what kind of high functioning autism is that. I know some people, like I said, who graduated MIT and are productive members of society. I also know others who graduated university but are unable to work at all. They are high functioning, they're intelligent, but they have such severe levels of anxiety that they're just unable to work. And your child does. So if you think that the child will be a productive member of society, then it's normal planning for you. But if you think that for whatever reasons that your child has limitations, he will not be able to work, then you should be setting up a supplemental needs trust before he turns 18. There's no need to wait till he is 18 years of age. You must set up the money for him so that it's available, but does not jeopardize his benefits.
Okay. And we have one final question, which I think I can answer. Can parents make their own special needs trust, or are lawyers necessary?
I have to say, I don't do legal work that is outside of my knowledge base because I know that I'm incompetent. I would not do my own personal injury case because I know nothing about it. I would not do my own business law because I know that I don't know the intricacy. I gave an example of how one missing word in a supplemental needs trust completely invalidated. This is such a specialized area of law that doing it on your own is almost guaranteed to make mistakes, always. And I have to, and it's not just for special needs, it's for any type of estate planning. People think that there's now legal Zoom and they can do all the type of planning on their own, and they don't need a lawyer. And I get people who bring me documents that they have created on LegalZoom for review to check. Not once over all these years that I've been doing it, not once have I seen it done properly. Not once. Not a power of attorney, not a healthcare proxy, not a will, and certainly not a trust.
Yeah.
There are just so many issues. You know, I did a class recently for other lawyers on the basics of a state of wills drafting. And I talked for 45 minutes and I had a ton of questions afterwards. It's not simple. There are lots of issues. I just like, I would not, you know, you probably would not do your own heart surgery on your own.
Not a great idea.
Don't do a special needs trust on your own.
Yeah. And look, given that we're talking a lifespan, when we're thinking about the cost and the effort initially, when you kind of average that out, it's as you say, we're really talking about risk management here, aren't we? Which you also know all about. So we are out of time. So really quickly, 3 things that you want our audience to go away with tonight. If they would remember nothing else, what would you want them to remember?
You have to plan both for yourself and then for your child. The two are related, but you have to take care of yourself first. I have to say, this has been a lot of information, and you probably will remember some of it, and then later will forget it, and you may not even remember this 5 days later. So remember that trusts are very versatile. They can be structured for any family situation. Remember that all plan must change um, as the family situation changes, and all family situation change for health, for family composition, for income, for changes in laws, of course, as well, and for science. So all of this must be reviewed periodically. And if you, my suggestion for you, for any parent, is it's overwhelming. I understand, and it's a lot of information. And you're going to do, and this is just another adding to your list of things to do. So my suggestion is block a calendar, a period, a block of time on your calendar for once a week for the next 4 weeks for 30 minutes. You can get the slides. You can email me and I will send you presentation of free presentation of 10 basic estate planning blocks that you can read as well. And then after you read this, you can actually figure it out, find a professional who will help you with this, and plan. But if you don't block out this time, it will just go on your back burner. It's really nice to do, and it's clearly not urgent because, of course, I'm not dying. And just remember, doing nothing changes nothing.
Yeah, and I think that is an excellent final piece to leave everyone with. Applies to life in general. Doing nothing changes nothing. So, Katya, thank you so much for your time and expertise this evening. I certainly learned a lot. I hope that our audience also learned a lot from tonight's presentation. As you all know, Katya is a face-to-face health provider. So if you do have any questions or would like to consult with her, don't hesitate to log into f2fhealth.com and you can go straight into seeing a provider and booking care with Katya. I do, before we finish off tonight, want to point out that next week we do have a break in our programming, but we are back the following week with the first in our COVID-19 series update, where we will be learning about COVID from a pediatrician's perspective. We'll be discussing some concerning childhood illness patterns over the last year or so, and that's with Dr. Shilpi Setia. Katya, again, thank you very much.
Thank you. Thank you for the time. I really appreciate it. And thank you for the questions. I'm so happy when people are interested and ask.
Yeah, absolutely. There were some great questions. So once again, to everyone out there, thank you for joining us. Please do visit our website to get more information about consultations as well as education. I just really quickly seeing one last question here. Oh, it's a nice smiley face. Thank you. All right. Good night, everyone, and take care. Bye, Katya.